over the years since the requirement was first enacted. And some of the changes are really significant. One of the changes, and I'm paraphrasing here, you'll have to go back and look at the history of the statute, but one of the really significant changes is that during periods of time, the disclosure statement required a seller to tell the prospective buyer and to disclose problems that they are aware of, and at other times it has required them to discuss and disclose problems that occurred during their ownership of the property. That's significantly different, because if they had purchased the property and later discovered a problem that had occurred, been caused or manifested itself earlier, they were technically under no obligation to disclose that in the disclosure statement. It doesn't mean you couldn't have a separate theory of action based on fraud or deceit or misrepresentation or something, but it may take it out of the scope of the disclosure claims. The disclosure statute obligates the seller by creating a limited remedy and rewarding the seller for being honest. The seller is relieved from liability for any defect or condition in the property if he discloses it. The disclosure must be made in good faith, and the remedy is limited because the statute says it's limited to, quote, the amount of the actual damages and repairs suffered by the buyer as a result of the violation or failure. Now, with some imagination, that can be expanded, but it still limits the remedy as opposed to other theories that may be viable in other types of bad house cases. The big advantage for a purchaser or for a seller here on a disclosure case is that the remedy includes attorney's fees in the discretion of the court. And of course, you know, as everyone knows, we have limited areas where we have statutory authorization for attorney's fees, and that can be really significant in a disclosure case. Now, the limitation also applies only to sellers. If you read the Fuller v. Croston decision, which is in, by the way, there are materials here that aren't in the book but that are available from Nicole up front. How much time, Craig? Okay. A real estate agent was named as another defendant in Fuller v. Croston, made it clear that the statute creates liability only for the seller. You can, of course, incorporate other theories against other defendants in the same action, but also made it clear that attorney's fees cannot be awarded against the seller or against the real estate agent, even if they're held liable for all or a portion of the verdict. Jury instructions given by courts in these disclosure cases are pretty basic. I still don't think there are any forms, but they can be. You can kind of cobble them together based on the statute, and it's not difficult to do. The construction defect type of bad house cases in general, the definition that I used earlier, again, and I'm beating a horse here, but the ability to pay criteria of the bad house case is really important. I'm sure there are many lawyers in here who've gotten into bad house cases. It was difficult to analyze the ability of a defendant to pay initially. Is there insurance coverage? If so, there's probably a reservation of rights. There's probably a very genuine issue about whether there's insurance coverage for anything. In some cases, in many cases, you have uninsured defendants. I'm sure there are lawyers in the room that have been involved in cases where there might be 10 different defendants who are named in the initial action. 3 or 4 don't appear through counsel, don't appear at all, don't answer their correspondence, don't have any insurance, have no intention of hiring a lawyer, and probably have no assets to pay any type of a judgment. That's what makes these cases difficult. So initially, you've got to identify the problems about potential payment, about insurance issues, and everything else. In the materials, I mentioned the decision in American Family v. Robnick. I think that was a case from out here in this circuit. And this relates both to the disclosure cases and the construction defect cases in general. The court in that case held that even though there were allegations in the complaint that the seller had negligently failed to properly complete the disclosure statement, and there was evidence to support that failure was negligence. Under those circumstances, that didn't constitute an accident or occurrence within the terms of the policy. Therefore, even though, as you know, you can plead negligence and maybe even prove it, in this case, American Family prevailed, and in a case involving failure to properly disclose under the requirements of the statute, our Supreme Court held that there was no coverage. Those kind of issues can be complex in these cases and need to be explored right away. Construction defect cases involve all kinds of defendants, real estate developers, soils people who did the site preparation, concrete subcontractors, general contractor, the carpenters, the roofers, the people that sold the windows who leak. I mean, everybody has been in those kind of cases where sometimes there's 20 defendants when you're all done. So, as a practical matter, the way most of these cases get settled is that a plaintiff gets really, really high, outrageous estimates for repairs. You have a mediation, everybody kind of holds their nose, and if there's some money there and they don't want to pay continuing costs of defense, the case gets settled. The plaintiff waits 2 or 3 years after doing some minimal fixes to see if there's any more problem with the house. Then they do a fix that's reasonable, and they use the excess money that's left over to pay their lawyer. That's the only way. That's the way that these cases usually can work. If you can't get that done, they're difficult to make work. The attorney's fees that a plaintiff is going to incur and the costs of litigation are the biggest concerns for a plaintiff. The biggest concerns for a defendant are the sentiments expressed in the poem I mentioned in the materials, which I don't recommend reading. It was written in Victorian style, and the last sentence of every stanza is, "There's no place like home." But people's homes are different and they're special, and that colors these cases to no end, both in the eyes of the parties and in the eyes of a jury. Rescission is a remedy that can be, if both parties are willing, can be used pretty effectively on these cases. Soils cases, I won't talk about them much because they lead to the other two types of cases in most situations, but the soils in western South Dakota are dangerous soils to build on, and you should know what you're doing, and it's always amazed me. I don't know if things have changed, but in Rapid City, at least until recently, the standard was not to do extensive soil borings on residential lots before construction. That was my understanding. I've been told that by people, and that was the rule that was followed or not followed in cases I've been in, and it's just amazing to me that that's the case. You can Google, and I can't do it, but I'll bet Jane could. But if you go on and Google Pier Shale, soil mechanics, and structural engineering, you'll get thousands of articles written in every language in the world by structural engineers and others about the dangers and difficulties of construction on Pier Shale, which is the predominant shale from the Missouri River west. And it is difficult. It's caused more problems in terms of differential movement in homes, landslides, instability for footings and foundations than you could ever imagine. I want to talk just briefly about rescission again. As I mentioned, that can be a valuable remedy, and it takes both parties, under most circumstances, to get to that point. But it has a couple advantages. One, a seller can get rid of property if they truly don't want it. Now, most cases I've seen, despite numerous complaints, in most cases sellers really don't want to get rid of the property. It's not always true. Or buyers don't want to get rid of the property, excuse me. Sellers very seldom want it back. But the goal of rescission is to put parties back into the position they were prior to the transaction, which means, yes, a seller engaging in rescission can be required to refund mortgage loan interest and principal payments, real estate taxes, but on the other hand, they get as an offset the reasonable market value of living in the home during the time the plaintiff lived in it. Rescission can be very valuable. Read the rescission case in the Snakes on the Plains case, the McCollum versus Cahill decision. Doesn't tell you much about what I'm talking about today, but it's interesting reading. So The measure of damages is still the difference between the lesser of the two, difference between the home before and after, or the cost of repair. Trial courts seem to be able to find creative ways of getting around that. So with that, I'll turn the mic back to Judge Feifele. Thanks for your attention.
Again, a reminder to please make sure that you fill out your evaluation forms and leave those for us before you leave here for the day. Our next presenter is Ron Parsons. Ron is a partner with the Johnson Heideprun firm in Sioux Falls. He is a regular presenter at this particular CLE on important appellate developments over the course of the last year, and we're lucky to have Ron back again this year to update us on what has happened at the Supreme Court level for the past year.
Thank you, Judge. Good morning. These are not necessarily the biggest cases or the most interesting cases, but those that seem like they've either made new law or changed the law somehow. I've noticed in the booklet, before it went to the printer, the font size appears to have changed, and that affected the spacing in the materials. So if you would like an original copy of the materials, please feel free to email me, and I'd be happy to send that to you. Start off in the world of civil procedure. Not a terribly big year in changing the law for civil procedure. The first case is Orr versus Cook, and that really just makes clear that prejudgment interest is not discretionary. So even if there is not a motion for prejudgment interest, it's not pled in the complaint, it's not discussed, it's not on the verdict form, you could still even do it when you're making a motion for taxation of costs after the case pursuant to 54D. The next case is Estes versus Lahnbacken, and that deals with pleading, and that reverses a line of cases that has caused problems throughout the years. It used to be that when determining venue for a civil action, the trial court could not look outside the complaint, and so you had complaints being drafted kind of cleverly to alter what would be the proper venue, and that is no longer doable. Those cases are reversed. I'll go down to appellate practice. Appellate practice, this has been a big year for notices of appeal. And this is probably the most dangerous area that I can think of, the most easy way to commit malpractice. But the Supreme Court has taken a very hard line in making sure that every party, no matter how seemingly insignificant, must be served with a notice of appeal, even if they're not involved in the appeal, in the issues that you've pled or who you've appealed against. If you don't serve every party, that is fatal to your jurisdiction and it will be dismissed. The first case was People versus XREL Department of Social Services. That was a special case involving the termination of parental rights, and there both the parent and the attorney must sign the notice of appeal. Here the parent did not sign it, and so it was dismissed. Estate of Geyer is the next case, and that's trusts and wills or probate matters are a danger area here. You have to serve every party, and here certain heirs were not served, and so the appeal was dismissed. The next case, Rabo Agrifinance versus Rock Creek Farms, and here it was a foreclosure action. 44 different defendants. One of them was the United States, who may or may not have had an interest in the case. The United States was not served. The appeal was dismissed. The next case is it's probably my favorite case name of the year. You have a case about problems with a will, and it's called Estate of Flaws. We always get cases that kind of match the issue. This is kind of an exception. I guess there's an exception for serving in a notice of appeal. You don't have to serve a notice of appeal on heirs who are purported nieces when they're represented by the same counsel. So that's probably very helpful to a lot of people here. Estate of Hamilton, there's another exception where there's a very limited issue about heirs in that case. In Kierstead Realty, this is where the Supreme Court had repealed a statute pursuant to its authority. There used to be a statute where a retrial on remand had to occur within 1 year or the case would be dismissed, and it didn't matter why. Here there had been active diligence in trying to schedule a retrial, and so the Supreme Court not only held that it could be retried and the dismissal was improper, but then they repealed that statute. So that's gone. State versus Lichewski is kind of a substance over form decision involving appeals, but even though something was labeled a judgment by the trial court, it really was an order, and so the notice of appeal deadline for orders in criminal cases applied. Go to the world of evidence now, and not much law in evidence, not much new law, case law. The one case that stood out to me was the first interpretation of what is the apology statute. It's been called SDCL 19-12-14, and that allows courts to exclude from evidence apologies by doctors to patients in medical malpractice cases, and this is the first case that really interpreted it. Tort law and negligence and causes of action. Linskov versus Linskov, it dealt with the question of when is a failure to disclose a fraud. It's a pretty interesting case. There was a sale of business between partners. There was not a covenant not to compete in the sale agreement, but the one cousin who was a partner intended all along to open a competing business in the exact same implement business just as soon as the sale was completed, and he did that. The Supreme Court held, though, that was not fraud because there was not a duty to disclose. It was an arm's length transaction. The next case, Fix versus First State Bank of Roscoe, I think is interesting because the Supreme Court has come down on the pro side in terms of availability of emotional distress damages in tort actions. There have been some conflicting case law suggesting that you couldn't always get emotional distress damages or the standard might be very high, but here it's a very expansive, in my opinion, decision. So if you have a tort, take a look at emotional distress damages. The next case, Danielson versus Hess, deals with malicious prosecution. That's the first time we've had a standard for third-party malicious prosecution where someone turns another person into the police maliciously and falsely, and here we have a standard at how that claim will be judged. Adrian versus Vonk is a case, I believe from the Pierre area, but it involved prairie dogs. The case really stands for the proposition that the Supreme Court is going to be very reluctant to infer a cause of action from the violation of state statutes unless those statutes expressly provide a remedy. So I think there's a standard there, but they've indicated a great reluctance to do that. Steinecke versus Deltzer is interesting. It is a seller of land case, and what are the damages? We finally do have a standard for what the damages are when there's a negligent misrepresentation associated with the sale of land. And here there had been representations that there was an adequate well. Turns out the well was not adequate. The purchasers sued, and they wanted the cost of installing an adequate well. The Supreme Court held that was not the measure of damages. Instead, it was out-of-pocket costs plus the difference in value of the property with and without the well. And that actually affirmed a prediction of state law by Chief Judge Schreier in a federal diversity case. In Highmark, Federal Credit Union versus Hunter, the essential point is that whether a federal statute creates a duty or establishes a standard of care for purposes of a state common law cause of action is a matter of state law, not federal law. And that's confused in some states. Cashman versus Van Dyke of tragic facts, but a homeowner's lighting of a pilot light is not an abnormally dangerous activity for purposes of strict liability, and the Supreme Court has adopted, I think now fully, the Restatement of Torts 520. In the world of contracts, not much terribly new. One case that stood out, it's kind of a case that's been, or an issue that's been around for centuries. It's whether or not a lease or a landlord has a duty to mitigate by trying to relet a property after a renter breaches his lease. But they dodged it yet again because here there was actually a contractual provision that required them to do so, and they left open the open question of whether, if the lease is silent on that, they'll save for another day the question of whether or not you must mitigate. In insurance, there's Desmarais versus DeSmit State Farm Mutual Insurance Company. Hard case for me to follow exactly, but it involves coverage, and it keeps in place the rule that the insurer always bears the burden of proving that the allegations in a complaint fall outside of the coverage for purposes of a duty to defend. But then it talks about where there are then exceptions to an exclusion in a policy. That actually burden is going to fall on the insurer to prove that the exception to the exclusion applies. So we have kind of a three-prong analysis now for coverage questions. But I'm not professing to completely understand that case. The DeSmit versus Poirier now states that an owned but not insured clause in an auto policy that excludes coverage for vehicles that are owned by an insured but not covered under the policy, that does not violate public policy, so those are fine in South Dakota. That was an open question. Family law didn't seem there was much new law. In the Urbaniak case, a trial court may consider VA disability payments as income when determining alimony. That was an open question before. In the matter of MV, makes clear that specific findings regarding a parent's role in alleged child abuse or neglect are not necessary in adjudicating a child's status as abused or neglected. The only question is whether they are, not why or how, in terms of entering specific findings of fact. And in matter of LS, the Indian Child Welfare Act does not apply to an ethnic Native American child who is not eligible for tribal membership as defined by the Act. Workers' compensation, I only found one question, and I guess you can double dip in workers' comp. If you live in one state and work in another, sometimes you can get work comp in both states. But South Dakota has held, at least, if you live in South Dakota but work in Wyoming, you can't get South Dakota workers' comp. There's no jurisdiction. Constitutional law, I thought, was really where there's a lot of big activity this year. The first case, State versus Good Plume, it deals with the constitutional issue of judicial disqualification. You don't have to show actual bias, but the appearance of bias is not enough for the purpose of the constitutional question, meaning a conviction won't be reversed unless you show the probability of actual bias. For purposes of the ethic rules that judges have to follow the ethical rules, though, the appearance of bias is still the standard they should apply to themselves. In re Dugard was the decision where the Supreme Court 3-2 ruled upon its own qualifications for residents in being sworn in as a Supreme Court justice. And it was a 3-2 decision. It seems strange maybe that the Supreme Court would rule on its own qualifications, but the Constitution has legislative officers do that as well. Daly versus City of Sioux Falls. For many years, the City of Sioux Falls had followed a policy where if you were in a dispute with them and doing an administrative appeal, you had to come in and prove your innocence of a violation, and the Supreme Court held that violated procedural due process. So the burden of proof is back where it should be on the city when they're attempting to prove a violation. But the interesting thing I thought was Justice Severson, in his opinion, noted that the South Dakota Constitution requires that there be judicial review of city administrative decisions, and there'd really been no avenue to do that. And he pointed that out, and then just this past session, the legislature, I think in a bill sponsored by Governor Hunt, changed that. So starting whenever the new laws go into effect this month, I think, in the 7 home rule counties, you can now appeal directly a administrative decision of a municipality to circuit court under the Administrative Procedures Act. In Davis versus State, we had the challenge to the education system in South Dakota. The South Dakota Supreme Court recognized the standard, recognized that there is a right to a free, adequate, and quality public education. and they held that it was a justiciable question that they could address, but of course upheld the state's, held that our system does not violate the state constitution. In Rapid City Journal versus Delaney, to me this is, I would be a nominee for Case of the Year just because it's a First Amendment case and it affirms that the First Amendment affords the media and the public a right of access to civil trials. Always it has existed for criminal trials, but even if the parties stipulate to close the proceedings or try to and the judge enters a gag order, the public or the media has a right to come in and challenge that order, and it's a fairly strict standard for trying to close a civil trial. John Arnerson in Sioux Falls and Rodney Schlager of Rapid City got the First Amendment win on that case. Law versus City of Sioux Falls is a state preemption case, and where the state regulates video lottery, municipalities can't come in even in a kind of backdoor way and try to regulate something that is regulated by the state. And it's another case where kind of the title sums up the issue. Law versus City of Sioux Falls. And the law won. Hall versus State is a takings clause case that develops the law. The world of property, not too much new. Now we have a standard for establishing an implied easement where we didn't have a clear one before. Criminal law. I think the Supreme Court is writing decisions and granting oral argument, it seems to me, in fewer criminal cases. So when you're working on briefs, try to find a way to get their attention, because there's a lot of summary affirmances in criminal cases, and almost all the cases that they do grant, they find something very interesting or new in the case, it seems. State versus Golding, this was where one friend asked another friend to kill him as a suicide, so he shot his friend, and they held that the murder statute applies regardless, not the assisted suicide statute. State versus Stark, loitering, prohibiting loitering in a community safety zone is not a non-constitutionally vague statute. State versus Jones, I thought, was my other nominee, I think, for Case of the Year.